Europe thought they'd won. In what was celebrated as the most aggressive economic sanction in modern history, the European Union seized $245 billion in Russian assets, frozen central bank reserves, confiscated oligarch properties, nationalized corporate holdings. It was supposed to Russia force regime change, demonstrate that aggression has consequences. The champagne was flowing in Brussels. Politicians competed for credit. Media praised European courage and unity. Then Russia's legal team filed a document, one document, 847 pages, filed simultaneously in 14 jurisdictions across 3 continents. Within 72 hours, European legal experts were calling it the most sophisticated legal warfare operation in history. Within 2 weeks, European governments were quietly panicking. Within a month, the $245 billion seizure, Europe's signature punishment against Russia, was unraveling. What Russia did wasn't military retaliation. It wasn't economic warfare. It was pure legal brilliance that exploited weaknesses in European law that nobody saw coming. And it's working. What I'm about to reveal is how Russia turned Europe's greatest weapon against them, why European lawyers are now advising their governments to settle, and what this means for the entire concept of economic sanctions. This is the story of how Russia destroyed Europe's $245 billion theft with one brilliant legal move. Let me start with what Europe actually seized. When Russia invaded Ukraine in February 2022, Western nations froze approximately $300 billion in Russian central bank reserves. The European Union held roughly $245 billion of this total, the largest portion. For 2 years, these assets sat frozen. Russia demanded their return. Europe refused. Then in November 2024, European leaders took the unprecedented step of actual confiscation, not just freezing, but seizing the assets and transferring them to a Ukraine reconstruction fund. The legal justification was creative. They declared the funds reparations for Russian aggression under principles derived from post-World War II international law. It was legally dubious. Multiple European legal advisors warned it violated international law, customary practice regarding sovereign immunity, and even the EU's own legal frameworks. But political pressure overwhelmed legal caution. The seizure proceeded. Russia's immediate response seemed muted. Angry statements, promises of consequences, the usual diplomatic theater. European leaders breathed a sigh of relief. If that's all Russia could do, complain. The seizure was a success. This was a catastrophic misreading of Russia's strategy. Russia's legal team had been preparing for this moment for 2 years, not hoping it wouldn't happen, planning for when it would happen. They assembled a team of the world's best international law experts, not Russian lawyers. That would lack credibility. They hired British, French, Swiss, American legal experts, top-tier firms with impeccable reputations. These lawyers spent 2 years analyzing every aspect of the asset freeze, looking for vulnerabilities, studying precedents, building arguments. They identified something European lawmakers had overlooked in their rush to seize assets. The legal mechanism Europe used to freeze and then seize Russian assets depended on classifying them as state property subject to civil enforcement. But under international law, there's a crucial distinction. Sovereign immunity protects certain state assets from seizure, even in the context of sanctions. Specifically, central bank reserves held as monetary policy instruments enjoy absolute sovereign immunity under multiple international treaties and customary international law. Europe's lawyers knew this. That's why they spent 2 years with assets frozen but not seized. The seizure was legally problematic. When political pressure forced the seizure anyway, they tried to work around sovereign immunity by classifying the action as reparations rather than judicial enforcement. Russia's legal team identified this as the weak point, and they exploited it brilliantly. The Russian legal filing, 847 pages across 14 jurisdictions, argued the following. First, the seizure violated customary international law regarding sovereign immunity. Central bank reserves aren't ordinary state property. their monetary policy instruments protected by absolute sovereign immunity under the UN Convention on Jurisdictional Immunities of States and Their Property. The EU's own courts had previously upheld this principle. Russian lawyers cited European case law extensively. Second, the reparations justification was legally invalid. Reparations require either a peace treaty establishing terms doesn't exist, a judgment from an international tribunal with jurisdiction doesn't exist, voluntary agreement obviously doesn't exist, unilateral declaration of reparations by one party to a conflict isn't legally recognized. Third, the seizure violated European Union's own legal frameworks. Multiple EU treaties and regulations protect property rights. The seizure didn't follow EU's own procedures for property confiscation. Russian lawyers argued that EU law was being selectively applied, protecting European property rights while ignoring Russian property rights, which violates fundamental EU legal principles. Fourth, the president endangered global financial stability. This was the brilliant strategic argument. Russia wasn't just defending its own interests. It was arguing that allowing this seizure would undermine the entire international financial system. If sovereign reserves can be seized by political decision, no country's reserves are safe. This creates incentives to move reserves out of Western financial systems, destabilizing global finance. Russia positioned itself as defending international financial order against European political expediency, but the Russian legal filing didn't just make arguments. It included something unprecedented, evidence of coordination. The filing included communications showing that EU member states had disagreed on the legality of seizure, that internal EU legal opinions had warned against it, that the decision was political, not legal. How did Russia obtain internal EU documents? The filing didn't say, but the implication was clear. Russia had access to European internal deliberations. They knew the doubts. They knew the warnings that were ignored. This created panic in Brussels. If Russia had these documents, what else did they have? Were there leaks, hacking, sympathetic insiders? The uncertainty was almost as damaging as the actual evidence. European governments couldn't even determine how their internal communications ended up in Russian legal filings. The jurisdictional strategy was equally brilliant. Russia didn't file in just one court. They filed in 14 jurisdictions simultaneously. International Court of Justice, ICJ, European Court of Human Rights, ECHR, Permanent Court of Arbitration, commercial courts in London, Switzerland, Singapore, investment treaty tribunals under multiple bilateral investment treaties, even U.S. federal courts under foreign sovereign immunity statutes. This created a legal nightmare for Europe. Each jurisdiction had different rules, different procedures, different timelines. Europe had to defend the seizure in 14 separate legal proceedings, each requiring different legal teams, different strategies. The cost alone was staggering. Europe would spend hundreds of millions just on legal defense, but worse was the risk of contradictory judgments. If any one jurisdiction ruled the seizure violated international law, it would undermine Europe's position in all other jurisdictions. Russia only needed to win in one court to create massive legal problems for Europe. Meanwhile, Europe needed to win in all 14 jurisdictions to definitively establish legality. The asymmetry was overwhelming. Within weeks, the first legal setbacks emerged. A Swiss commercial court issued a preliminary injunction freezing certain European actions related to the seized assets pending further proceedings. This didn't return the money to Russia, but it prevented Europe from using the funds for Ukraine reconstruction, the stated purpose of the seizure. The money sat in legal limbo, not available to Russia, not available to Europe, just frozen. Then the Permanent Court of Arbitration issued a similar order in a different proceeding. The European Court of Human Rights agreed to hear Russia's case on an expedited basis, signaling they saw potential merit. None of these were final rulings, but they were signals that courts were taking Russia's arguments seriously. European legal confidence began cracking. The investment treaty claims were particularly clever. Russia had bilateral investment treaties, BITs, with multiple EU countries. These treaties protect foreign investment from expropriation without compensation. Russia argued that seizing Russian central bank deposits violated these investment protection treaties. EU lawyers countered that central bank reserves aren't investments covered by BITs, but Russia's legal team had evidence that EU member states had previously argued the opposite position in other cases. They cited EU legal positions that broadly defined investment to include sovereign financial assets. This was devastating. Europe was contradicting its own previous legal positions. Under international law, states can't adopt contradictory legal positions opportunistically. That's called estoppel, and courts rejected. Russia was using Europe's own past legal arguments against them. The financial sector's reaction amplified the crisis. Global banks, sovereign wealth funds, and central banks watched nervously. If Europe could seize Russian reserves, they could seize anyone's reserves. Capital flight from European financial institutions began. Not massive, not panic, but steady, significant outflows. Countries reduced euro reserve holdings, diversified away from European assets, moved funds to jurisdictions with stronger property protections. This hit European financial markets. Bond yields rose. The euro weakened. Borrowing costs for European governments increased. The European Central Bank faced an impossible situation: defend the seizure and accept financial instability, or acknowledge it was legally problematic and undermine political objectives. They chose studied silence, which helped no one. Let me show you the domino effects. European insurance companies that provided political risk insurance suddenly faced massive potential liabilities. If the seizure was ruled illegal, they might have to pay out on policies covering Russian asset seizures. Insurance premiums for political risk coverage in Europe spiked. This made European investments less attractive. European banks holding or managing Russian assets in other jurisdictions faced legal liability. If courts ruled the seizure illegal, they could be sued for participating in it. Legal departments at major European financial institutions began advising clients to reduce exposure to any transactions that might be connected to the Russian asset issue. The complexity spread throughout the financial system like a virus. The political ramifications were equally severe. Eastern European EU members who had pushed hardest for seizure now faced voter backlash. Their economies closer to Russia felt retaliation harder. Western European members who had been skeptical from the beginning said, "We told you so," and distanced themselves from collective EU responsibility. The unity that made the seizure politically possible was fracturing under legal pressure. Some EU members began quietly suggesting settlement, return some assets in exchange for Russian dropping legal cases. Others insisted that would be weakness, that Europe must fight every case to final judgment. The internal EU debate became public and acrimonious. Russia's legal strategy wasn't just attacking the seizure, it was attacking European unity. Now let me show you the truly brilliant part of Russia's strategy. They weren't actually trying to win every case in court. Some cases they probably will lose. International Court of Justice cases take years and are unpredictable, but Russia doesn't need to win every case. They just need to create enough legal uncertainty that Europe can't use the seized assets. The money sits frozen in legal limbo. Europe can't give it to Ukraine because courts have issued orders preventing it. Russia doesn't have it back, but Europe can't benefit from taking it. Meanwhile, legal costs mount, political divisions deepen, financial market instability continues. This is legal warfare as attrition strategy. Europe thought seizing assets was a one-time action with permanent effect. Russia turned it into an ongoing legal battle with mounting costs. The precedent implications are profound. Future sanctions regimes will be limited by this case. If Russia succeeds in establishing that sovereign reserves enjoy absolute immunity, even in the context of sanctions, then the West's most powerful sanction tool, freezing central bank reserves, becomes much less effective. Countries will know they can eventually challenge freezes in court and potentially win. This undermines the psychological impact of sanctions. If sanctions can be fought and overturned legally, they're less frightening. China is watching carefully. They're seeing how to legally challenge Western sanctions. They're taking notes on Russia's strategy. Other countries facing potential Western sanctions are similarly learning. Russia is providing a blueprint for legal resistance. European legal experts are now quietly advising settlement, not because they think Europe will definitely lose all cases, but because the costs of fighting indefinitely exceed the benefits. Hundreds of millions in legal fees, financial market instability, political divisions, precedent risks for $245 billion that's frozen in legal limbo. Anyway, some European officials are privately asking, what if we just return most of the money and negotiate limits on future Russian actions? This would be politically devastating. An admission that the seizure was legally indefensible, a victory for Russia, but continuing to fight risks even worse outcomes. If major courts rule the seizure illegal, Europe has to return the money and pay Russia's legal costs and accept precedent that undermines future sanctions. Settlement starts looking attractive compared to that scenario. Russia's negotiating position gets stronger every day. The legal cases continue. They're not demanding immediate return of all funds. They're willing to negotiate. Perhaps some funds go to neutral international development programs. Perhaps some are used for Ukraine reconstruction with Russian oversight. Perhaps some are returned in exchange for specific Russian commitments. Russia is positioning itself as reasonable, willing to compromise, just want legal recognition that the seizure was improper. Europe is positioned as intransigent, defending an increasingly indefensible legal position, spending vast sums to fight the inevitable. The optics are shifting in Russia's favor. Let me show you the human element that makes this particularly clever. The European lawyers defending the seizure are top international law experts. They know international law. They published articles about sovereign immunity. They taught courses on this exact subject. Now they're arguing positions that contradict their own previous scholarship. Some are privately uncomfortable. They took the cases because governments hired them, but they know the arguments are weak. This internal conflict creates subtle problems. Arguments lack conviction. Filings are competent but not brilliant. There's no passionate defense because the lawyers themselves have doubts. Meanwhile, Russia's legal team includes some of the same experts who wrote the definitive texts on sovereign immunity. They're arguing positions they genuinely believe in, supported by scholarship they themselves created. The quality difference shows Russia's filings are tighter, more convincing, more thorough. In legal warfare, confidence and conviction matter. The timeline favors Russia. These cases will take years, during which the money sits frozen, unusable by Europe. Meanwhile, Russia has adapted to sanctions. Their economy stabilized. They found alternative trade partners. They built workarounds. The urgency Europe felt in 2022, we must punish Russia now, has faded. In 2027 or 2028, when these cases finally reach judgment, European public opinion might be, why are we still fighting about this? The political will to continue might evaporate before legal proceedings conclude. Russia is betting on European attention span being shorter than international legal timelines. It's a reasonable bet. Here's what keeps European strategists awake at night. If they lose these cases, if courts rule the seizure violated international law, they're admitting that Europe itself violated international law. This undermines Europe's entire foreign policy posture. Europe claims to defend rules-based international order. They lecture other countries about respecting international law. A judgment that Europe violated international law destroys that moral authority. China, Russia, Iran, every country Europe criticizes will cite this judgment. You violated international law yourselves. Why should we listen to you? The reputational damage could exceed the financial loss. The brilliance of Russia's legal strategy is that it turned Europe's strength into weakness. Europe's strength, legal systems, rule of law, judicial independence. Russia's strategy. Use those legal systems against European political decisions. European courts are independent. They rule based on law, not politics. European judges will follow legal logic wherever it leads, even if it embarrasses their governments. Russia is betting that European legal principles Europe is proud of, will force European courts to rule against their own governments. This is judo, using opponents' strength and momentum against them. Let me be clear about the outcome. Russia probably won't get all $245 billion back immediately. Some assets will remain frozen or confiscated, but they'll get enough back and create enough legal chaos that the seizure will be remembered as a European defeat, not victory. The political symbolism matters more than the specific dollar amount. Europe tried to demonstrate that aggression has consequences. Russia is demonstrating that European power has limits that can be challenged legally. Which message will prevail in global consciousness? Based on current trajectories, Russia's message is winning. The broader implications for sanctions regimes are profound. Western sanctions have been the primary tool of economic statecraft for decades. The assumption was that sanctions, especially asset freezes, were essentially permanent. Once frozen, assets stayed frozen until political settlement. Russia is proving that assumption wrong. Sanctions can be challenged legally. Assets can potentially be recovered through legal process. The finality of sanctions is questionable. This changes cost-benefit calculations for countries considering actions that might trigger sanctions. If sanctions are temporary and challengeable, they're less deterrent. The entire edifice of Western economic statecraft is being undermined by Russia's legal strategy. For Europe, this is a disaster wrapped in legal complexity. The general public doesn't understand the legal nuances. Politicians can still claim victory in seizing assets, but legal and financial experts know Europe is in trouble. The costs mount, the precedents worsen, the outcome looks increasingly unfavorable. Europe seized $245 billion in a moment of political unity and anger. Russia is systematically destroying that seizure through patient legal warfare. One brilliant legal move, filing in 14 jurisdictions simultaneously with arguments exploiting weaknesses, European lawyers should have anticipated turned Europe's triumph into Russia's opportunity. This is how modern great power competition works, not tanks and missiles, legal filings, and jurisdictional strategies. The sophistication is remarkable. The implications are profound, and most people have no idea it's happening. Europe's $245 billion theft, because that's what it was, legally speaking, is being destroyed, not by Russian military might, by Russian legal brilliance. And there's nothing Europe can do to stop it without abandoning the rule of law, principles they claim to defend. Russia found the perfect strategy. Force Europe to choose between legal principles and political objectives. Europe can't have both, and Russia is making sure everyone knows